come out the way I think I did come out. I'm just getting a little tired at the end of the day. You were asked to do something specific, right?
Sure.
It was to calculate the buyout of the master employment agreement.
That's right.
And the thing that you were asked to do that was very specific wasn't including anything that exceeded the four corners of that document, right?
That's right.
And Mr. Preston's claim, as you further learned at a later point, actually included things beyond the four corners of that document, right?
No, I didn't learn that at a later point. It was included in at least a reference to possible claims was included in the settlement letter that I reviewed. So it wasn't information that came to me later.
It was information you knew, you just didn't calculate anything beyond the four corners.
It's information what, I'm sorry?
It was information you knew, but you just didn't calculate anything beyond the four corners, correct?
That's correct.
With respect to potential tort claims, you didn't do any work trying to evaluate the economic value of tort claims, did you?
I did not.
Doctor, if you don't mind, let's just tick through a couple things in your report, and I think I can try to finish up a little bit. If you'll turn, I believe the first report is Defense Exhibit 53. On page 2 of your report, Doctor, there's a section at the very top. It's not numbered, but it says duration of severance pay period. Do you see that?
Yes.
And in that section, the duration of the severance pay period is identified as 36 months, correct?
Yes.
So the term, or the unit of time that we'll be looking at, is a 36-month period with respect to calculating the buyout amount underneath master employment agreement.
If you're, I want to be careful answering that because you and I talked about this a week ago. The duration of the severance pay period was 3 years, 36 months. I did not consider that a term in the sense of his compensation per term. I considered that to be annual compensation.
Well, respectfully, you jumped ahead of me a couple of questions. All I wanted to know was, does your report reflect that the duration of the period of time of that issue in the severance pay period is at 36 months?
36 months, that's correct.
So the unit of time we're looking at is 36 months.
Yes.
And then down below is the part where I think you skipped ahead, which is okay, and that's under number 1. And the question I have for you there is that what you did, if I understand correctly, was you calculated the salary provision underneath the buyout amount at $167,838 because that was Mr. Preston's salary then in effect, correct?
At this termination, yes.
But another way you could have done it, Doctor, in calculating a rate of pay was to look at the unit of time as 36 months, correct?
No, you and I talked about that. I could not have done that. You could do that, and you apparently have chosen to. When the phrase says, at the rate of pay upon termination, I interpreted that to mean the annual rate of pay.
A rate is compensation over time, right?
I considered it to be the annual rate of pay.
I understand that, Doctor, but I'm just asking you a more basic question.
And it is.
A rate is the compensation over a period of time.
Sure,
right?
it might be an hourly
And your opinion assumed that the unit of time should be 12 months.
For measuring his rate of pay, yes.
And up above, when we look directly above, where it says duration of severance pay period, you can see there you use the unit of time of 36 months.
Of course I did.
In relation to the master employment agreement, which is under tab 1, Plaintiff's Exhibit 1, Page 5, Section 4 includes a section entitled Salary, does it not?
I'm sure it does, yeah.
And what Section 4 on page 5 of Plaintiff's Exhibit 1 reflects that the administrator, at any given time, was entitled to a pay step increase on an annual basis of 2%. Correct?
That's correct.
And when the finance director for the county, who calculated the buyout amount, that really is an issue, she increased the amount by 2% in year number 2, in year number 3, correct?
She may have, I don't know. We talked about that earlier. I don't know who made that computation.
Your calculation assumed a flat amount in year 1, year 2, and year 3, right?
That's correct.
And the other calculation did remain flat. It increased by some amount in year 2. It increased in some amount in year number 3, right?
The other calculation?
The
That
calculation.
in the settlement offer? Yes.
Yes. Now, Doctor, if I understand your report correctly, pushing back to defense 53, I'm sorry to jump around on you so much. The second item was about Social Security and Medicare taxes, employer. And what I wanted to know about that item was, did you at some point become aware that that specific item, that specific amount, which I think was about $24,243, did you ever become aware, did anyone tell you, that that amount was specifically discussed between opposing counsel, one for the county, one for Mr. Preston, during their negotiations on the severance agreement?
Yes, I had a copy of the correspondence.
You had a copy of their correspondence. So
Yes.
you knew by reviewing that correspondence that they didn't know what to do with that number, correct?
No, I didn't know that.
So did you not have all of the correspondence?
I saw an explanation from Mr. Preston's counsel, Rob Hoskins, saying here's how I computed it. I don't know what the parties ultimately agreed to. My opinion was simply this: the demand, the settlement letter asked for compensation before the end of 2008. My whole point was this: if that's when the compensation was made, then the employer FICA would not exceed the 1.45% Medicare payment, because Mr. Preston's total compensation would have already exceeded the Social Security maximum.
I understand that. What I was specifically trying to ascertain, Doctor, was whether your opinions with respect to the $24,000 number took into account or were informed by the pieces of correspondence, one from Tom Bright to Mr. Hoskins and one from Mr. Hoskins to Tom Bright, that specifically cite the exact number that you've identified in your second section of your report.
No, it did not. I mean, I was asked to assess what I thought the value would be, and that's what I did.
And as to items 3, 4, 5, and 6, as I understand it, you didn't really have any issues with those items, correct?
That's right.
As I understand it, item 13 is the same sort of fishbone that's caught in our throat as relating to section 17D of the Master Employment Agreement. And that is to say that to answer the issue you identify in section 13 is going to require some sort of legal interpretation. Is that right?
Are you talking about supplemental long-term disability insurance?
Yes, sir.
13.
The next contested item is section 13, correct?
In my report, number 13 says supplemental long-term disability
Correct.
insurance.
And then, if you turn the page to page 4, Doctor, the first line of the next section. Oh, wait, did I get this out of order? Is that the problem? No, I got it. The next section says, and I quote, "This wording is subject to legal interpretation," does it not?
Yeah, but that does not relate to just item 13. That
Right.
relates to what I talked about in my direct examination. All of that life, health, dental, and disability insurance.
Basically all of the insurances, right?
Sure.
And the issue there is a legal interpretation needs to be made, and you're just not the guy who's going to do that, right?
That's what I said. That's why I did it 2 ways.
Doctor, as always, I've enjoyed talking to you, and I appreciate your willingness to come down and testify today. Thank you for your time.
Thank you.
Right, Mr. Gentry? Thank you, Ron. Yes. Dr. Alford, brief. All lawyers commits their things that way. Mr. Davis asked you a couple of questions that related to items 1 and 2 in the notebook that he handed you, which are respectively the Master Employment Agreement and the Severance Agreement and Release of Claims. Let me ask you, if you would, to look first at his tab 2, the Severance Agreement and Release of Claims, paragraph 6, the release that he talked to you about. Is it your understanding that is an actual release provision that is designed to release claims?
I
Do you
don't
have an
know. He read it to me, and I said it looks like a broader release than the other one, but I don't have a whole lot of opinion about legal releases.
Fair enough, and I think let me ask you one more question, and the answer may be the same. If you look at under tab 1 at the Master Employment Agreement on page 4, Mr. Davis asked you about the last item on that page, which is subsection E. Do you have an opinion about whether that is actual release language as opposed to being a promise to enter into some release in the future?
No, I don't have any opinion about that.
Mr. Davis asked you about your knowledge of the bona fides of Sharon Graham and Tammy Nichols, who provided the affidavits on which you relied for your second report. Those affidavits are stipulated as testimony in this case. Do you recall whether those affidavits identified for whom those two women worked?
Yes. Sharon Graham is Program Director of Custom Claims, South Carolina Public Employee Benefit Authority. I don't recall the other lady.
Your report says that you relied on the Sharon Graham affidavit. It's
That's
possible
correct.
that you did not rely on the Tammy Nichols affidavit.
I never referenced her affidavit.
I'm going to take this opportunity to hand up 3 exhibits that have been pre-admitted. They're Plaintiff's Exhibit 76, 76A, and 77, which are the 2007 and 2008 Palmetto Agricultural Consultants Agreement, and then the draft that was transmitted between Michelle and Mr. Preston dated October 27.
I'm sorry, 76.
76, 76A, and 77.
Yep, no problem.
You want me to approach? And I've identified these together, Dr. Alford. My question for you is going to be only about 77, which is the 2008 PAC contract. Mr. Davis suggested to you that a good way for the county to get out of its buyout obligation under this contract would be to pay Palmetto Agricultural Consultants an hour a week.
Your Honor, I object to the question. I have no point actually said anything along those lines. I just say that we'll reduce the minimum. I didn't say anything about trying to get out of the contract.
Oh, thank you. Mr. Davis asked you questions about what the value of this contract would be if or the value to Palmetto Agricultural Consultants of the flow of payments would be if the county paid, engaged her for only 1 hour a week. Do you recall those questions?
I do.
And Mr. Davis also asked you if you were aware of any provision in this Exhibit 77 that provided for a minimum amount of hours.
No.
All right. Let me
Yes, he did ask me.
And you said you were not aware of that.
That's right.
Let me direct your attention to the 3rd page of this contract, Exhibit 77. Do you see, first, item 2 identifies services to be provided. Is that correct?
That's correct.
And there are then 5 bolded areas of endeavor for PAC. Is that correct?
That's correct.
And do you see down below that paragraph 2.2?
I did.
I'm going to read 2.2 and you just identify tell us whether I've read it correctly. 2.2, vital services. Anderson County recognizes that the services under this agreement are vital to Palmetto Agricultural Consultants, LLC, and must be continued without interruption. Did I read that correct?
What do I think about it? I think that if all those services identified in those 5 items are to be done, they not be done in 1 hour a week.
Your Honor, it's getting late today, so I kind of appreciate why it's occurring, but this is witness, so I understand that I get to lead the witness, but I was unaware that he can call an expert and then rehabilitate him by leading him, so I have to object to this.
Go ahead.
I wasn't sure precisely how I led him, I just read him the provision of the contract.
Well, leading is, in my definition, is when you ask questions that suggest answers. I'll urge you not to do that.
All right, sir. Do you have any understanding, Dr. Alford, about whether the services to be provided under this agreement could be accomplished in an hour a week?
No.
No further questions.
You got any further? No. Sir, you may step down. I would assume that you'd like to release this witness. Is that
We would,
correct? Any objection? Mr. Davis?
No.
Dr. Alford, I do need to make you aware, as I have all witnesses, there is a sequestration order in effect for all witnesses, and witnesses are required not to discuss their testimony even after they've testified with anyone until this case is concluded. Do you understand that, sir?
Yes.
Thank you very much. You have a good afternoon. All right, we're going to take a short 5-minute break. The court will be in recess.